The issue was raised last week as to defense wishing to bring out the Commonwealth not having obtained a DNA sample from Mr. Wallace. At that point, the Commonwealth had objected on the grounds that Mr. Wallace had refused to provide such a sample. I'll hear you on the motion.
Thank you, Your Honor. As set forth in our filing this morning, in fact, Mr. Wallace did not refuse to provide a sample. Mr. Wallace affirmatively, through his attorney, offered to provide a sample voluntarily on March 7th, 2014, which is contrary to the representation made to the court last week. The Commonwealth apparently chose not to take Mr. Wallace up on his offer and never obtained his sample. I think the case law of Bowden and progeny are quite clear that we have an absolute right under both Massachusetts law and under our right, the state and federal constitutional right of confrontation, to establish that this was a deficiency in the Commonwealth's investigation. It shows bias in their investigation. It shows incompleteness in their investigation, and that those are appropriate matters for cross-examination, and they're appropriate matters for the defense to bring out at trial. And for those reasons, we ask the court to allow us to elicit from this witness or potentially other witnesses that the Commonwealth did not obtain Mr. Wallace's DNA sample and therefore did not have it available for testing or comparison purposes.
Your Honor, just to clarify, this was a motion that I had sent to, it wasn't filed with the court, I had filed with the attorney for Mr. Wallace. I had represented at the sidebar that he didn't consent, and in fact, that I still stand by that in the context of, I sent it to him, it was either late January, early February. He hadn't had an opportunity. There was some number of weeks that had passed. He hadn't responded to that. He responded to me with that email on March 7th. I had received the results on March 4th, and I've had this conversation with counsel as to the timing of this. At that time, I had no further basis to seek DNA from him. He hadn't consented during the course of the time that I actually had a basis, and which was subject to my motion, which...
So at the point you had asked, the Commonwealth was, as with Mr. Hernandez, had sent to both Mr. Hernandez and Mr. Wallace motions that they intended to file in court to seek a court order.
Yes, Your Honor. And
Mr. Hernandez responded more promptly.
He did.
And by the time Mr. Wallace responded, the results had already come out.
That's correct, Your Honor. So, and as I indicated, there was no basis at that time for further, I mean, in good faith, I couldn't then say, because he did send me the email and says, okay, well now he will, but this was after I had already had knowledge of the results. So it had essentially undercut the basis of my motion, and I didn't have any other items at that time that I could suggest, well, I'm still going forward on the motion for these reasons. So essentially the items that were referenced in my motion, which I will submit, were regarding the ones we're talking about now with Ms. Fife, the cigarette and the casings and the things that were in that batch of evidence. So with regard to my statement, I brought this to counsel's attention that when I had suggested that he hadn't consented, it was because I know I would have persisted in then seeking his DNA, but for the fact that I received the information that it had already been answered. So, so I don't think that creates a Bowden-type situation, as counsel is suggesting.
Let me add, Your Honor, long after March 7th of 2014, the Commonwealth conducted DNA testing on other materials, including a cartridge casing that was found in the Enterprise rent-a-car dumpster attached to a piece of blue chewing gum. They didn't test that, Your Honor, until, I believe, August. So it's not like all the DNA testing in the case had been done, and therefore there's no reason to get Mr. Wallace's DNA. And frankly, Your Honor, I think that that is a frivolous argument, that they were continuing to do DNA testing, and they did DNA testing on other items as well, Your Honor, all the way through the summer and into the fall, I believe, of 2014.
And Your Honor, I would just say, obviously we have to have a basis. If we're going to come into court and suggest someone should be compelled.
So by that time, by April of 14, Mr. Wallace had been charged with, indicted for murder, for this murder.
I believe it was maybe in April.
April 11 of 14.
Yes, Your Honor.
So certainly, at that point, after that, he had been indicted and charged with murder at the same murder. So in terms of relevance, in terms of bases, and I assume you had a basis when you were about to file your motion prior to March 7th. The Commonwealth believed it had a good faith basis when it sent the motions.
That's right, Your Honor.
Thank you.
Thank you.
I will allow an inquiry. I think it is relevant, and the Commonwealth is certainly free to put on, to have a witness explain that why it chose to wait to see whether whether Mr. Wallace was going to consent or not, when they hadn't heard, if it was sent to them in January and they hadn't heard by the time that the DNA testing was being done, why the Commonwealth, what steps the Commonwealth took to consult with his counsel as to were they going to get an answer, and if they were being stonewalled by Mr. Wallace, why the Commonwealth chose not to seek a court order. Commonwealth is free to explain why, with respect to objects that were tested after the result came back, other objects, why they did not take Mr. Wallace up on his offer in March 7 to voluntarily provide a buccal swab, and they're free to explain with respect to objects that were never tested, why they didn't seek to get the DNA because they weren't intending to test those objects, and why they weren't testing those objects to the extent the defense questions about objects that weren't tested. So I think at various points it's relevant, and the Commonwealth will be allowed to respond to any failure to test inference that the defense is seeking to have drawn from its questioning as to whether Mr. Wallace's DNA was ever obtained.
Your Honor, I accept that ruling, and I understand that he can ask if there's a basis for suggesting an item that naturally would have been tested, they can ask about that. What I guess I'm concerned about is that there's a potential for misleading as to other items where we had the information, things were tested, and again, going back to Wallace, it said inconclusive as and insufficient to do any further testing. So the idea that there are these items where either there's a mixture in something that's been undefined,
right,
but knowing full well we couldn't do anything further with it, that it wouldn't be suggested in a way that we should have been doing something like getting Wallace's DNA, because again, we had nothing to test against.
I agree completely, and certainly if the Commonwealth, if the defense asks about a particular item, well, you could have used it for this, and the response is no, we couldn't, they're obviously going to run the risk of appearing in a certain fashion by asking a question.
That's what redirect examinations for you.
Well,
I don't know whether there were objects that were never tested at all, and obviously often the DNA analyst will say, I test what I'm asked to test, and I didn't test
the blue bubble gum.
I didn't test something because I wasn't asked to test it, and they then have their ultimate argument as to these things should be tested, and the analyst may only be able to testify, I didn't test it because I wasn't asked, or maybe the analyst made an independent determination, and the Commonwealth certainly can put on whatever evidence it wishes as to why it chose not to ask that certain items be tested at all. And to the extent they're inquiring about things that are inconclusive for a limited purpose, the witness, this witness has knowledge, or if she doesn't, whichever witness has knowledge, certainly will be able to testify. The instruction I gave with respect to inconclusive tests is out of the sort of case law that says you normally would not put in that it's inconclusive, but you can put in it's inconclusive for the very purpose of demonstrating that tests were performed and the result was inconclusive.
Which I cited to the court this morning.
And that's sort of consistent with a response. Clearly, the defense opens that door to putting in more inconclusive tests if he decides to go down that route.
And I understand that, Your Honor. I'm just asking that the question wouldn't be, I don't think it's a fair question to say, well, if you know it's inconclusive, they can't do anything further. Adding the name, like Wallace, well, did you test Wallace, or you didn't test Wallace against these items? Because, again, you have to have a good faith basis to ask the question to know there would be a reason. So to the extent that...
They didn't test anyone against those items. They didn't test Hernandez either. So, yes, I think that...
I don't think we're doing that here.
Okay, fair enough.
Your Honor, real quickly, a separate issue. This witness testified a few minutes ago. She made reference to, quote, potential testing by the defense. And I would ask the court to instruct the jury that the defense has no obligation to test anything, and that the burden of proof is solely on the Commonwealth.
Right, I did that this morning with respect to a different witness. I will repeat that.
Thank you.
Thank you. We'll take a 15-minute recess.
All right.